Another big topic for us to discuss and understand is the system of bodies within the WTO and the process of decision making. With so many members currently participating in the work of the WTO, it is important to understand how decisions are taken and what are the ways to effectively influence those decisions that members have. The structure of the WTO bodies is very much reflective of the structure of the WTO legal texts, of the WTO agreements. And the next slide will help us perfectly understand how it all works. But to begin with, we need to understand that the major decision maker within the WTO is the meeting of ministers that happens no less than once in 2 years. That is the ordinary course of doing business with the ministerial conference. There may be changes in the schedule caused, for instance, by any global pandemic or whatever, but otherwise ministerial conferences happen every 2 years, and ministers, respective ministers of the governments, come to different places where the ministerial conferences are held to discuss the ongoing situation and the most urgent burning matters that relate to international trade on the one hand, on the second hand, to make any decisions on new rules and approve, for instance, some important accessions to the organization, if any, are in the pipeline. Clearly, you understand that ministers do not do all the work from scratch. Usually the ministerial conferences are well prepared, and ministers would go there with the understanding of what documents will be proposed for signing and approval, and they are usually approved well in advance. So it's more of a formal meeting to see each other, to make sure we discuss the tendencies in international trade, the direction international trade is going to, but the decisions are usually prepared well in advance. The ministers participating are different. It's not prime ministers. Usually these are ministers that are responsible for trade and responsible for external trade relations within the respective governments. For the government of Russia, it is the Ministry of Economic Development, for instance. The Minister for Economic Development would go to the ministerial conference. However, as ministerial conferences are held only once in 2 years, a lot of questions need to be resolved on a day-to-day basis, and many of the decisions should be taken on a daily basis, including the decisions on accession. If the next ministerial conference is only in 1 year and a half, the General Council has the capacity to approve the decisions in absence of the ministerial conference. The General Council, which is the major day-to-day functioning body of the WTO, consists of the representatives of all WTO members. Those are usually trade diplomats, heads of representatives, heads of embassies. That all depends on the particular decision of the WTO member. They can assign any person they deem necessary to be their representative in the General Council. So the General Council is the body where all WTO members meet on a regular basis. The meetings of the General Council are usually held once in a month, unless there is any other urgent need to do it more often, or if there are some other reasons not to have meetings every month. And the General Council can take operative decisions which are necessary in the moments when the ministerial conference is not in the pipeline. And the General Council, also here you may see to the right from the General Council, there are two boxes when it is again General Council, but it is labeled as General Council sitting as dispute settlement body and General Council sitting as trade policy review body. So when reading the texts of Annex 2 and 3 to the Marrakesh Agreement, the DSU and the TPRM, you will see the references to DSB, Dispute Settlement Body, and TPRB, trade policy review body. So these two organs, these two bodies within the WTO are actually the very same General Council, but sitting under a different hat. So the meeting of the General Council is held once a month. The meeting of the dispute settlement body on the general is in general is also held once a month. Trade policy review body would meet as soon as necessary, depending on the schedule of the review of trade policies of the members. So when we talk of dispute settlement body, don't expect that to be a group of lawyers who are just, I don't know, former judges or who represent their governments as leading academics, professors, or whatever. That can well be, they can be lawyers, they can be professors, but those are the members of the General Council. This day they are sitting under the hat of the dispute settlement body, and they decide all the matters of the dispute settlement body in the same manner as they do for the trade policy review body, in a way that, again, it's no other representation there. It's no one different from the same WTO members sitting there. And then there is one more aspect of dispute settlement, which we need to mention now, though we will get back to the topic of dispute settlement further in our course, that there are dispute settlement panels and appellate bodies. They are not marked as direct bodies of the WTO of the WTO General Council or all of the WTO. They are not strictly speaking within the system of the WTO bodies. Why so? Because they do not make any decisions themselves. All reports of the panel and reports of the appellate body are sent for adoption to the dispute settlement body. So ultimately, no decision of the panel, nor any decision of the appellate body would come into legal effect unless approved by all WTO members. Panels, we will talk about that in more detail, but now for you to have a general understanding how things work, panels actually would be called what we call ad hoc. So panels are not permanently functioning groups. It is not like judges in national courts. For a particular dispute, 3 panelists would be called to resolve it and prepare the panel report, which they then send for approval to the dispute settlement body. So those panelists can be, again, any professionals. Usually they try to balance the panel composition. It should be maybe a lawyer, an economist, and a trade diplomat at best. But in any case, those are professionals which will be selected for the resolution of a particular dispute. And once the dispute is over, once the panel stage is over, their work is over. They are no longer functioning. They are no longer getting any salary from the WTO. So those are not, in a way, functioning bodies of the WTO. Unlike the appellate body is indeed a functioning, permanent group of 7 judges. They are usually most respected professors of law that come from different parts of the world. And again, the composition of the appellate body is a balance in sense of representation between the major members and between the major regions. And the appellate body has a very limited scope of review of the reports of the panel. They check whether they applied law correctly, just like the cassation review in many of the continental national systems. So the cassation court would not go again in the facts of the case, would not check whether the facts were established correctly. They would just check if there are any significant errors of law that have been made by the lower instance, in our case by the panel, and if there is a mistake, they could correct it. And in the appellate body stage, new facts, for instance, could not be established, and sometimes the appellate body would say that they do not have enough facts to make any finding because the panels did not establish the necessary facts, and therefore they cannot complete the analysis. because they cannot again raise questions, collect all the comments. They cannot make new expertise, for instance, if needed, if any expertise is needed. So the appellate body is a body of 7 functioning lawyers, which are selected for a limited term, and then they can be re-elected once again. Currently, you might have heard that the appellate body of the WTO as of 2020 is not functioning because we don't have the complete bench. We don't have at least 3 appellate body members that do still have their term not expired. The United States, at the times of President Obama and then further under the government of Donald Trump, do not re-elect. They block the re-election of the appellate body members just because they are not happy with the approach the appellate body was pursuing in a number of disputes, and they were not happy with the standing of the appellate body with respect to a number of US trade practices. The United States believe that the appellate body is exceeding their original competence, that they are involved in some judicial lawmaking, what should not happen, and they are seeking some form of, as they claim, reformation of the appellate body. But we will talk about this situation and the outcomes of the not functioning appellate body currently when we talk about WTO dispute settlement. So as for other WTO bodies which are of interest, under the General Council, you may also see several councils and committees. And if you recall the structure of the WTO agreements, Annex 1A, Annex 1B, and Annex 1C, it will not be difficult for you to understand the presence of the Council for Trade in Goods, Council for Trade and Services, and Council for Trade-related aspects of intellectual property rights. So these 3 councils are actually administering the questions relating to those particular fields of substantive rules, substantive obligations. And in case of any concerns that WTO members have with respect to those questions, they can raise those issues on the platform of committees and councils. So the WTO remains an extremely convenient tool for negotiations, because in case of any concerns on foreign trade policy, before any formal dispute would be raised, there will always, well, in most cases, there will be a discussion on the platform of a council or a committee to understand the position of the foreign government, to collect more information on the measures at issue which are subject of concern, and to understand how to resolve the problem that WTO members have identified. So the Council for Trade in Goods would also have committees which are reflective of those Annex 1A agreements which we discussed. Committee on Agriculture, Committee on Sanitary, Phytosanitary Measures, subsidies and countervailing measures, technical barriers to trade, anti-dumping, countervailing duties, rules of origin. So those are all the agreements which are known to us, and Committee on Market Access, mainly questions on access to foreign markets, mostly those questions which we are usually considering as GATT matters. And there is also a small working party on state trading enterprises, which also meets from time to time to discuss the evolution of regulation in this field. As for the Council on Trade and Services, they are also committees, but you remember that in Annex 1B, we don't have any other agreements but for the GATS, the General Agreement on Trade and Services. So committees here would just focus on particular fields of services of most interest for some of the WTO members, trade in financial services and specific commitments. We will talk about specific commitments in the next lecture. So now just take it as it is, and you will then understand what it actually means. And there are working parties on domestic regulation, on the GATS itself, and on the rules that need to be further developed in the field of trade services. There are also separate committees for plurilateral trade agreements, which you also remember. an agreement, a separate committee on informational technology agreement and a separate committee on civil aircraft and government procurement. And then we have the committee on trade negotiations, because there are a lot of negotiations apart from the existing rules, that for the further development of rules and the accessions to the WTO as well. So this is a separate committee which is responsible for all ongoing negotiations, trade negotiations, and apart from the so-called Doha development agenda, because now we are in the Doha round, and when talking about the future of the WTO and the current challenges, we will mention the Doha round separately, but this is the ongoing trade round, which has not advanced that far and as far as many expected. But still, this is the ongoing round of trade negotiations. On the one hand, you see negotiating groups on market access and rules. We also see a lot of special sessions on various aspects of ongoing negotiations. And then, irrespective of all this structure, which so far is more or less clear and reflective of the structure of the WTO legal text, there is a big group of committees and working groups that have been formed separately and that report directly to the General Council. Those are cross-sectorial groups that could not be put within the framework of one particular committee, and therefore they formed one separate council, and therefore they were put aside as a matter of separate committees. Those are questions of trade and environment, trade and development, assistance for less developed countries, special and differential treatment, subcommittee on least developed countries, clearly those countries which are to the most disadvantage in international economy and trade, committee on regional trade agreements, which oversees the work of governments in all directions to conclude free trade agreements, customs unions, which we will clearly talk about more in detail, and committee on balance of payment restrictions, and committee on budget, finance, and administration. Working parties on accession also directly report to the General Council. So once there is any progress that has been reached and the country is ready to accede to the WTO as the new member, it will be notified to the General Council to take further appropriate steps. And there are working groups on trade, debt and finance, and trade and technology transfer, which are also regularly meeting. So these groups are all available to all WTO members who wish to participate. And if the WTO member joins the meeting, if the WTO member shows up in the meeting, then the WTO member has all the rights to participate, express their views, they shall be heard, their position shall be taken into account. So there is no division between WTO members on their level of access to any of those committees. All those are open. And there are several meetings daily in the main building of the WTO in Geneva. And the WTO members are free to join those meetings that they deem necessary and interesting for them. It is not obligatory to go to those meetings, and if WTO members choose not to go, the meeting still gets held, and the WTO members will get the agenda and the findings that will be circulated by the Secretariat if any findings or any discussions or any minutes would be prepared. So all these meetings, as I said, are held sometimes even simultaneously. They can be there can be several meetings held at the same time in different rooms of the WTO. Therefore, WTO members should always keep track on what is going on, what discussions are happening, and make sure they do not miss what is important for them particularly. The WTO is very keen to emphasize that the WTO is a member-driven organization. So we have seen the structure of this WTO bodies. Let's even get back to it. You see that there is no body which is not available to WTO members that makes any decisions apart from the WTO members themselves. Director General of the WTO is performing just administrative functions. He's in charge of making all this work to make sure that the meetings are ready, that the agenda is circulated, that the panel, for instance, is composed, so that everything is running. However, he does not make any decisions that are vested only with the members in the system. All decisions approved by all members and not otherwise. So within the system of the WTO, we don't have anything similar to the United Nations Security Council that can issue decisions binding on all UN members. Within the WTO, all decisions are taken by all members. And according to the provisions of the Marrakesh Agreement on how decision-making should be performed, the WTO shall continue the practice of decision-making by consensus, which was followed under GATT 1947. Except as otherwise provided, where a decision cannot be arrived at by consensus, the matter at issue shall be decided by voting. That's what the Marrakesh Agreement Article 9 says. However, we should be very careful in reading it and understanding it. Question number 1, how do we understand consensus? So consensus is not the situation when everyone agrees, and that is important. Let's see the footnote 1 to this provision. Footnote 1 in the Marrakesh Agreement reads as follows. The body concerned shall be deemed to have decided by consensus on a matter submitted for its consideration if no member present at the meeting when the decision is taken formally objects to the proposed decision. Mind this difference. Consensus is not everyone in favor of the decision, everyone supporting the decision, and everyone voting for this decision. Consensus is a situation when there is no WTO member who formally objecting. So if the WTO member didn't show up at the meeting, then there is consensus because no one formally objected. And then the formal objection is still a relatively rigid diplomatic move. So countries tend not to formally object unless they see any great need to do that. So the body concerned is deemed to have decided by consensus if no one formally objects. And this is the practice that is implemented by all WTO bodies. At the end of the meeting, the chairman would ask if anyone has formal objections, and if formal objections don't follow, then the decision is considered to be taken by consensus. That is important. If you go and read the Marrakesh Agreement, which I invite you to do, you will see that the Marrakesh Agreement does provide for voting. There are 3/4 majority votings and 2/3 majority voting for accession, and 3/4 for the interpretation of the WTO agreements, for waiving the obligations of a WTO member, so for permitting a WTO member to violate rules if he specifically requests so, or not fulfill any of the obligations, and for amending the provisions of the legal text. However, and there is even a rule that one member has one vote for each of the European Union members, then they have individual votes, and EU, when voting together, votes for all of them, for all the 27 now, if I'm not mistaken, following Brexit, 27 members of the EU. But in reality, such voting never happens. And in practice, institutionally, the WTO is very much against any voting. All decisions are taken by consensus. It is important from a political viewpoint because whenever you go for voting, you demonstrate that there has been some element of coercion. There has been some disregard to the position of one of the WTO members. So from the diplomatic standpoint, it is very unlikely that any WTO body chair will accept the idea of voting just because there is no institutional practice of that. All decisions that have been taken from 1995 have always been taken by consensus. And therefore, no formal voting was there. There have been threats of voting, and indeed, one of the most recent examples was a big discussion on the Russia's accession to the WTO, and there were objections raised during the preparatory meetings by Georgia, and Georgia threatened to raise formal objections. But following the identification of those concerns by Georgia, there was a group, the working group formed, and additional negotiations were held between Russia, Georgia, and all the interested countries, the European communities, and Georgia was convinced not to raise formal objections. So when the decision on Russia's accession to the WTO was made, there was no formal objection on the side of Georgia. And thus, Russia did not become a member to the WTO as a result of voting. It acceded by consensus. However, there was a moment of tension in between Georgia and Russia when Georgia was threatening to raise formal objection. Russia was saying, if you do, then we request voting, and two-thirds majority will support our accession in any case. Therefore, there was this ping pong of some unpleasant diplomatic behavior and then remarks, but ultimately that situation has been resolved. And when I say that there has never been a situation of voting within the WTO, I should say that there is one caveat that shall be added. Some time ago, when all this Russia-Georgia discussion was very hot and in place, the press was saying that it should not be a problem to vote for the accession of Russia because there has been a precedent of voting, and it was the accession of Ecuador in 1995. If you check the accession, the protocol of accession of Ecuador of 1995, indeed you see that the protocol mentions that it has been approved by two-thirds of the WTO members. It was very old times, the first days of the WTO. Clearly, there was no understanding how to frame those issues, and maybe there was voting, and maybe there was no voting. It was just copying of the phrase from the Marrakesh Agreement. We would not know now, but clearly we understand that this precedent, even if it happened, did not form any institutional practice. And the WTO until today is going only through the consensus mechanism of taking decision. So whatever decision has to be taken, it has to be taken by consensus, and we don't have any institutional practice of voting. However, there are several additional matters which we should keep in mind when thinking of this consensus rule. On the one hand, as I said, consensus permits you to get rid of the question of quorum. So even if 5 WTO members show up, then that meeting is purely legitimate just because there is no formal objection raised if any decision is taken, though it never happens in practice. And yes, there is the rule of formal equality of the WTO members. Yes, one member has one vote, but in practice, we should understand that decision-making is more complex than it seems from the text of the Marrakesh Agreement. One important problem is that many of the WTO members cannot afford having big trade missions, monitoring all the ongoing discussions and going and visiting all the meetings and sessions which they may be interested in. For some countries that have only 2-3 representatives or even one representative for all international organizations in Geneva, they are bound to choose, those representatives are bound to choose which meetings to visit. And it may happen in some of the sessions that one representative of, say, Same, Ecuador will not only be representing Ecuador, but can also be representing Costa Rica and I don't know, Peru or any neighboring country, if the representatives agreed among themselves that they will not be available in this meeting and they requested the assistance of a friend. Well, clearly it's a small community and all representatives know each other and they can make such requests, especially the neighboring countries from the same region. And there is no formal requirement of any power of attorney or authorizing letter. Therefore, sometimes members agree to represent each other if they don't have the capacity to be there, but their presence is still required for any issue to be raised, but then they can split. But still, there is also one more important thing that we should understand, that there can be some less overt pressure tactics, as they are sometimes called, when WTO members would not have the capacity to really effectively participate in negotiations. If it's not only understaffed delegations, but they can be, well, overworked, understaffed delegations, and then those delegates can be involved in all night long negotiating sessions, sometimes without translation to their local languages, and therefore it may be difficult for them to work in English or in French and Spanish, and therefore they get really mentally exhausted. And at this point, a minimal compromise would be just to accept the deal as proposed by the developed country in its favor. That may sometimes happen. So that is the disadvantage of small countries. Bigger countries, EU, US, can afford having huge missions, 40, 50 people, delegates, diplomats working, lawyers working specifically on WTO, whereas some smaller countries cannot afford that. And generally, Geneva is a very expensive city in a way that not all countries afford having their missions there. Sometimes there is just no funding available for that, and therefore those countries may be underrepresented. And then secondly, we should understand that decisions are not taken just by the general discussion, all members sitting together and endlessly debating and debating. Clearly, all the key decisions would be taken, would be first proposed and agreed upon by the major economies, then more and more additional members could join. There were times in 1980s, early 1990s, when most of the decisions should have first been approved, so-called, by the Quad, Japan, Canada, EU, EC in those times, and the United States. Now, clearly, the list of countries that need to be on board for the initial discussion is much broader, with the greater expansion of greater proliferation of WTO members, greater expansion of geography of WTO membership. We need to now keep in mind the interests of more economies, including smaller countries as well, but should they be, for whatever reason, important in that particular decision that is being considered, they will be invited. So we used to call this green room negotiations because of the green room, which actually had green walls. And that was the room booked by WTO members for preliminary discussions. Once they have, the major economies have any clarity on the decision amongst themselves, they would add further new members for the discussion. And then when the matter is proposed for discussion in the General Council, there is usually a lot of work standing behind it before it actually gets proposed for any approval. But clearly, it doesn't make sense to discuss everything with 100 or 160 or 160 members on a daily basis. So for most decisions, they are decided in couloirs and then brought to a broader attention of the WTO members. So there are advantages and disadvantages of that. We should not be overwhelmed by this consensus tactics, because sometimes this unwillingness to go for voting may be to the disadvantage of the organization. But that is where we are, and that is the practice, the dispute settlement, that is the practice that the WTO has been following through the last 20 years, even 25 years, right? 1995, 2005, 2015, 25 years this year. And there is a big exception, an important exception to consensus rules. As I said, all decisions are taken by consensus, but there is an important exception. And this is the exception that actually relates to this jewel in the crown of the WTO, the system of dispute settlement. You remember we mentioned that in the GATT times, contracting parties, because all decisions were taken by consensus, and we see the Marrakesh Agreement says we will continue the GATT practice of taking decisions by consensus. But in the GATT times, decisions taken by consensus could have been blocked by one of the contracting parties raising the formal objection. That is not the case in the situation of dispute settlement before the World Trade Organization. The World Trade Organization operates on the rule of reversed consensus when it comes to the questions of dispute settlement, to the most key elements of dispute settlement. So, in order to launch a case, to start a case, you need to establish a panel that will hear the case. And then in Article 6.1 of the DSU, we read that a panel shall be established at the latest at the DSB meeting following that at which the request first appears. So in the second meeting after the request first appeared, unless the DSB decides by consensus not to establish a panel. So the panel will be established in all situations unless the DSB decides by consensus not to establish a panel. What would that mean? That would mean that all WTO members need to raise formal objections, or there should be a decision not to establish a panel, but there will always be a formal objection by the WTO member initiating the establishment of the panel. So in the way Article 6.1 is structured and written, there is no veto power to the respondent that is not willing a dispute to be initiated. Same rules apply to the adoption of panel reports, the adoption of the appellate body reports, Article 16 and 17 of the DSU. There is the same rule that those reports would be adopted unless the DSB decides by consensus not to do it. What is next to impossible to reach? There will always be one party that is satisfied with the outcome of the dispute, and that party will seek for the adoption. And there will never be a way to get the negative or reversed consensus so that not to adopt the decision. The same rules apply with respect to compensation and suspension of concessions. These are the forms of liability for non-compliance, retaliation, and also in Article 22.7 when it comes to the determination of the quantum of this liability, to what extent the WTO member would have the right to retaliate. These are the five exceptions to the general consensus rule. In all other cases, decisions within the WTO are taken by consensus. No one formally objects. However, here we need to ensure that when we talk of the dispute settlement, there is still decision taken by WTO members. All these decisions are taken by DSB. So formally, the decision is still taken by the dispute settlement body, either to establish a panel or to approve a panel report. However, they are approved, these decisions are decided, approved next to automatically. Some criticize the WTO for rubber stamping decisions of the panel report of the appellate body, because it is next to impossible to block the decision that has been proposed by the appellate body and the panel. It is to the big disadvantage to the system of dispute settlement, because the losing party does not have options to block the decision. On the other hand, it is not typical of an international dispute settlement mechanism, because again, in most international courts, most dispute settlement mechanisms, the losing party can be not accepting the decision, and then this decision will not be made effective, or no enforcement at least will happen against the losing party unless the party wishes it. So within the WTO, we have developed a completely new system as compared to the WTO, to the GATT dispute settlement. And now within the WTO, decisions of the panel of the appellate body are adopted as if, well, let's be frank, automatically. And the establishment of the panel can also not be blocked by the responding party. So that makes a big difference in a way that now WTO dispute settlement system functions very effectively, because the respondents are obliged to respond. The respondents cannot block the decisions, and the respondents can be subject to retaliatory measures if they do not comply. And therefore, this reversed consensus rule made a negative consensus rule made a big difference in the number of disputes. There have been, as we already saw, around 600 formal trade disputes initiated, and the formal dispute is the last resort, it is the last step if negotiations were unsuccessful, and if negotiations didn't work and consultations didn't work. So we will talk about that in more detail once we talk about dispute settlement. However, at this stage, we already understand that the WTO is indeed a member-driven organization. Indeed, all decisions within all WTO bodies are taken by WTO members, and they all can formally object, and the consensus rule is still valid, irrespective of the text in the Marrakesh Agreement. However, as for dispute settlement mechanism and dispute settlement reports, the decisions shall not be approved by consensus, but they work on a reversed consensus basis. So that is as for the question of decision making within the WTO.